session. You may be seated.
Good afternoon. Just a brief reminder that the unless the court has entered an order otherwise, the case is live streamed on Administrative Office of the Court's website, YouTube site, and then will be posted 2 or 3 days later, so it will always be there, so for better or for worse. Call the first case, please.
Susan Oaks et al. v. Mark A. Fox, M.D. et al.
We'll hear from the appellant.
Thank you. Good afternoon, may it please the court. I'm Ira Long. I represent.
If you would, please pull the microphone just over towards you. You can scoot it over. It'll scoot over.
All right.
I think so. You can move
I
it.
represent Susan and Randy Oaks, and this is partly a.
Counsel, you want to reserve any time for rebuttal?
I would like to reserve, say, 4 minutes.
4 minutes?
4 minutes, yes.
That'll be fine.
Thank
Go
you.
ahead.
So it's a case where one issue what was the scope of the summary judgment motion? Did it cover the claims that were made, and those that it did include, were there sufficient facts presented to the trial court to negate an element of those claims? This is not a put up or shut up situation. This was the defendant was to negate these one element at least of the plaintiff's claims. So the complaint has 2 parts. The first claim is for medical negligence. The second part is for informed consent. The motion for summary judgment does not address the first claim for negligence. It only addresses the second claim for informed consent. And what I'd like to do is I'll go through briefly the negligence claim, and I'll loop back to the motion for summary judgment. And you will not find any reference in the motion to deviation from the standard of care, negligence, anything like that. So Ms. Oaks had early stage breast cancer. And in general, what is necessary is 2 things. One is to remove the breast cancer, remove the cancer. That can be done by lumpectomy, by mastectomy. It depends on the situation. And that is so that's one thing that has to be done. The other thing that has to be done, cancers are staged in different ways. For breast cancer, the staging process has to do with the lymph nodes under the arm. You have to have lymph nodes to stage the cancer. The surgeon's other job is to get lymph nodes, and there are 2 ways to do that. One is take out the entire network of lymph nodes, which can interfere with the lymphatic drainage from the arm and cause arm lymphedema. The other way, developed about 25 years ago, is a sentinel node biopsy. One is a dissection. Dissection in this case means take them all. Biopsy means take a couple, because it was discovered that instead of having to take them all, because we don't know where the cancer would have entered the lymph nodes, now it can be identified. The nodes that the cancer from this breast tumor goes into can be identified by dye that's put in, and so it's called the sentinel node, okay? The sentinel node. So if a patient qualifies, instead of having all of their lymph nodes removed to check for cancer and to stage the cancer, they can have a dye procedure or radioactive material that'll flow down into the sentinel nodes, the ones that are going to receive the cancer first. Those can be taken out, tested. If there's no cancer, it would have been a waste to take them all out, and it would have risked arm lymphedema. If they do need to come out, then that can be done later in another surgery. So The claim for negligence is, number one, that Ms. Oakes received the dissection when informed consent has nothing to do with it. The patient could consent 1,000 times, and if the surgeon walks into the operating room and performs the surgery, they're negligent. The evidence in this case is that in order to consent for that surgery, if you qualify for the biopsy, in order to have the dissection, you must specifically reject the standard of care. And that came up with our expert, Dr. Eford. He has been painted as doing this. He said, well, this is what happened to Ms. Oakes, but I do the same thing. Wasn't quite right. Dr. Eford doesn't do the same thing. He does the same thing after he has he was asked whether you've done the surgery. He says, yes, I have. And so, on a patient just like Ms. Oakes, well, yes. Assume Ms. Oakes wanted a double mastectomy and she wanted multiple nodes removed. Would you have a multiple nodes, meaning a dissection, would you have a moral reason not to? This is record at 375, 376. And here's what he says. He says, I wouldn't say I wouldn't do it, because I have had patients that say, well, they don't like the sentinel node. Well, what's the failure rate? It's 2% miss rate. I've had patients who want all of them out. So if I were going to do that, there would be volumes I had dictated. I mean, I would be able to see that and read it. I've met with her 3 times. She insists on doing this. She understands this is not the standard of care. She is putting herself at increased risk for lymphedema. That's the consent that it requires to get all the nodes taken out when a biopsy is as effective, less invasive, and does not run nearly the chance of lymphedema. So he was then asked, well, is the purpose of charting CYA approach to explain what you've done? And his answer was, it's not so much for the attorney, it's for all of my colleagues, because they're going to look at that chart and they're going to say, you're an idiot. I'm not sending anyone else to you anymore. And, I'm going to report you to the board. It's just unprofessional. I wouldn't want to have my process recorded just for the sake of it being documented. I mean, the attorneys, if they get it, that's the end of the road. That's not really why I do it. Well, that's what this case is. It's the end of the road. This surgery should not have been done. And that's our case. They don't have a case that contravenes that. They don't have an expert. They have our expert. And they explained his testimony as he does it on the same people, just like Ms. Oakes. He does it if he's met with them 3 times, they've rejected the standard of care. And you ask, well, why would he do it? Why would he do it if it's not standard of care? You have to stage the cancer. You have to know whether this is a cancer that needs more treatment. Does it need chemo? Does it need nothing? What does it need? That's the only way to find out. So that's why he would do it. Now, the other claim that's negligence is a botched surgery. Ms. Oakes had essentially half of her breast removed by Dr. Fox. How do we know that? Because the defense hired a pathologist to look at tissue that was removed in Crossville and at Vanderbilt. And using the left breast, because the right breast had cancer, but using the left breast, Dr. Fox removed approximately 58% of the breast. The surgeon at Vanderbilt removed 42% of the breast. And that was not a cosmetic procedure. That was a procedure to finish that surgery. And the argument in this case is that surgery was optional, it was cosmetic, and we don't see how you can possibly say that it was cosmetic. They say, well, she could have just had her chest monitored. She had she planned a double mastectomy, and she ended up with 58% of her breast removed. And the defense is she could just have her chest monitored. She could just keep getting just keep getting mammograms. Well, that's treatment too. And to live with that wouldn't make any sense. So looping back to the motion in this case, the motion for summary judgment says, because I think listening for the negligence in it is going to be, it's not there. Number one, Dr. Fox properly obtained informed consent from Ms. Oakes and properly educated her on their options. Informed consent, not negligence. Her revision surgery was purely elective. That is not negligence. And third and last, lymphedema is a known complication of any surgery affecting the lymph nodes. Those are all, has to do with damages. Not a word of negligence in there. And she does have damages, and she's pled them, both specific and general. She's pled pain, suffering, disfigurement, loss of enjoyment of life. She had a second surgery. There's a myriad of those. None of those have been addressed. The only ones that have been addressed is lymphedema. We acknowledge that any surgery can, that affects the lymph nodes can cause. The point in this case is it's so much higher, the risk, that it's beneath the standard of care to even do it. Okay? And so that leaves the informed consent claim and the basis of that claim that she was given informed consent or she consented was it says she refused because she didn't want radiation. If there's a lumpectomy, you have to have radiation of the breast. Question and answer. This is on page 308 of the record. And I'm just about to run out of time. I'll return to this, but this answer is cut off at "but if." The quotation is here. The citation of the record is here. The quote in the brief is here. The quote cuts off at "but if." That's Ms. Oakes' answer is "but if," and it's cut off. And the whole answer needed to be there to put it in context.
Thank you. You have your time for rebuttal. We'll hear from the appellee.
Good afternoon. I'm Rachel Hurt here, Rachel Hurt of the Knoxville
If you don't
Bar
mind,
here on behalf.
You can slide it over in front of you. You can stay there, but
The microphone will move,
yeah, the microphone
the whole
will move.
thing.
I'm sorry.
Like the whole.
The base
Oh, the
will
whole
move.
base.
Yep.
Got it.
Yes.
Is that better? Okay, thank you.
Thank
I
you.
apologize. Rachel Hurt of the Knoxville Bar here on behalf of the defendants. I had my prepared remarks, but after listening to what has been stated so far, I think it's important to discuss right now that we're talking about two different cases. What I just heard were facts that are not in the record before the trial court. What I heard were facts that could have been presented, but were not. They were not the facts that the court considered because the court granted the defendant's motion to strike the untimely filed responses that were filed the day before the scheduled motion for summary judgment. And that motion to strike and the decision of the trial court to grant that motion to strike is not on appeal in this matter. That was not an issue sought for review. And so the inquiry here is based upon the undisputed facts that were accepted by the court because there was no timely response in accordance with Rule 5603. Based upon those facts, did the defendants carry their burden of proof to negate either a claim at trial or negate an element or prove that an element could not be proven at trial? And it's the defendant's position that we did do that at the trial court level. And I can start and end with, frankly, a very detailed order of the trial court. It's 9 pages long. It has attached the court's ruling, the analysis of the court, what the court considered, and how it reached its decisions. The court was very clear in how it reviewed the facts that were before it. It talked about its reliance on the Owens versus Bristol Motor Speedway case, all the way back in 2001, and then going forward to even the most recent case of that Owens progeny in 2021. The court understood that it needed to, once it accepted our facts as true, was there any genuine issue of material fact that such that defendants did not carry their burden. And so in doing that, I argued, and the court listened to the two claims that are in this case, and that is informed consent and medical negligence. I'll start with the informed consent argument. The reason I spent so much time in Dr. Efert's deposition asking about whether he had ever performed this procedure before is because in White versus Beeks, B-E-E-K-S, a 2015 case of the Tennessee Supreme Court, the court held that if a reasonable person, after being given information about the surgery, if a reasonable person would choose that surgery, then that is not lack of informed consent. And so I asked Dr. Efert in this case, have you ever done this procedure before, the exact same procedure that Ms. Oaks elected to have? Yes, I have. All right, I want you to take a patient as similar as Ms. Oaks as humanly possible, alike her in every way. You've given her the 4 treatment options, and undisputed fact 1, 4, and 5, she was given her 4 treatment options for breast surgery. If you've given her those 4 treatment options and the patient, just like Ms. Oaks, chooses this surgery, would you do it? Yes. Have you in fact done it before? Yes. How many patients choose the procedure that Ms. Oaks did? His answer was, and this is all in the record, in my brief, in the trial court, his answer was 75% of patients choose sentinel node biopsy and lumpectomy, the lesser invasive procedure. But that leaves this 25% who don't. And so if the standard of care is that, if the standard for informed consent is no reasonable person could choose it, there's this 25% of the population every day that does, or some portion of that 25% that does.
Ms. Hurt, was there evidence in the record of this plaintiff explaining why she did not want to do the sentinel node biopsy? Was she concerned with radiation?
Yes, Your Honor. So she was asked directly by me, and Dr. Fox testified to this as well, that she did not want radiation treatment. And the standard of care, it's unequivocal, or it's undisputed by both sides, although maybe not in the technical record, but it is undisputed by both sides that if you choose to get a sentinel node biopsy, a standard round of radiation would be required. And that's in the discovery responses of Ms. Oaks that she was given all 4 treatment options. In addition to establishing that White versus Meeks standard of a reasonable person would choose this, and in fact has, and Dr. Efert, plaintiff's sole expert, has done this surgery. The other component of that is our undisputed material facts, 1, 3, 4, and then 6 through 11, delineate why there was informed consent, what was discussed, what was agreed to, what Ms. Oaks consented to, that she chose to have the procedure she had. And once she chose a double mastectomy, and once she chose the actually lymph node dissection, her damages for removal of her chest wall, her damages for disfigurement, which was claimed, her damages for removal of her axilla tissue in her right armpit, those damages went away because no longer was Dr. Fox the cause of those damages. It is because Ms. Oaks elected those procedures. And so we negated damages, informed consent, and proved a reasonable person.
I mean, was there an allegation of negligence in the performance of the surgery itself?
Yes, and I'm pivoting right now to that, Your Honor.
All right.
The second claim is that there was medical negligence in the performance of the procedure. I will agree that nowhere in our undisputed material facts does it say Dr. Fox did not violate the standard of care. That's not what we alleged. And the reason we didn't allege that is because it wasn't clear just by stating those words, because that question was never asked of anybody. It wasn't clear how Dr. Fox didn't violate the standard of care. And so what we did instead was attach and rely upon the pathology expert report of Dr. Krasik. And the claim in this case, although it's unclear because it's not from the complaint, the claim in the complaint is because Ms. Oaks' chest wall was not flat after the first procedure, the procedure was negligent. And she did have a second surgery to remove tissue. And so I asked Dr. Efert about that removal of tissue in that second surgery. Her second surgeon, and it's an exhibit to our motion for summary judgment, agreed that that procedure was elective, discussed that it was mostly cosmetic. That's in the record. So I asked Dr. Efert, again, plaintiff's only expert, how much of that surgery, that tissue that remained, was breast versus fat? Because the inquiry for a flat chest wall or for a surgeon performing this procedure is, did breast tissue remain? Dr. Fox is not a cosmetic surgeon. He's not a plastic surgeon. That was not what the purpose of his procedure was. And so Dr. Karasik, through pathology, looked at the slides of the tissue removed in the second surgery and says, this is fat tissue. This is adipose fat tissue. Ms. Oaks had a BMI of 50, around 50, 48.5 at the time of this surgery. She did have excess fat in and around her breast area. But when the pathologist looked at the tissue, it was not breast tissue. And from that, she concluded that this tissue was in accordance with what she would expect to find from a cosmetic procedure, but that the proper amount of tissue with regard to removing the breast tissue had been completed. And so that is how we said that there wasn't a violation of the standard of care. When I asked Dr. Eford specifically about the excess breast tissue in his deposition, I asked him, well, can you guess? Because I asked him first, do you know how much breast tissue remained? I have no idea. Could you guess at the amount of breast tissue? He said, I can't say whether there was any breast tissue left or not. It's more than maybe I would expect, but I didn't examine her. Maybe there was breast tissue, maybe there wasn't. I have no way to know one way or the other. I have no way to prove it. That's at page 226 to 228. And then I asked him, would you defer to a pathologist in a review of pathology and the findings of those slides? And he said unequivocally, I would. I have no opinion on that. But it's not just in the performance of the procedure and how we attacked it with Dr. Karasik to say that there was no violation of the standard of care. It was also through damages, which is the fourth element of it.
Before you get to that,
Yes, sir.
I want to make sure I'm clear, though. Is it your position that your motion for summary judgment was both as to the informed consent and as to the alleged negligence related to the procedure itself? The performance of the procedure, not whether or not to do it, but the performance of the procedure.
Yes, Your Honor. And this was an issue that Judge Pemberton even specifically took under additional consideration and had additional briefing on that. Because our position was in the trial court, in the original hearing, and then in our supplemental briefing on this issue before the court ruled, is that there are 4 elements to a healthcare liability claim. And the 4th element is damages. The 3rd is causation. And on lymphedema, which was claimed to be from the surgery, not the way the surgery was performed, but because an actual lymph node dissection occurred, that the lymphedema was causal of the surgery. We negated that by saying, first, she chose actually lymph node dissection. Secondly, all the testimony on lymphedema was speculative, because Dr. Eford couldn't say one way or the other whether any of the procedures more likely would have prevented lymphedema from resulting. That was on the causation, and then went to the damages. The only claimed injury from the surgery is the need for a second surgery. The undisputed facts were that it was elective.
Well, I mean, I understand that's your conclusion, but my question was just, was there negligence? Did your motion go to the negligence in the performance of the surgery? Not that she chose it. Let's assume she chose it, and you taking care of informed consent. That doesn't mean that a doctor can then go in and be negligent during the performance of the surgery. Well, she chose this procedure, and okay, so that's everything's done then after this. If it doesn't matter what happens, she chose it. My question to you is, since that's so, did your motion ask for summary judgment, both as to that, including as to negligence in the performance of the surgery? Not because there were no damages because she chose it, not because there were no causation because she chose it, just the actual performance.
Yes, we challenged the performance of the surgery by establishing through the testimony of Dr. Karasik that the performance was appropriate. They're fixated on the amount of fat tissue that remained, not on what was proven to be minimal breast tissue that remained, and that established that the surgery was appropriate. That was our means of establishing that under a healthcare liability claim, not informed consent, but on the elements of a 29-26-115 claim, he did not violate the applicable standard of care. And that's our statement of undisputed material facts 17 through 23, and how we went through that. But then we went a step beyond that for the remaining, for all damages. The damages are undisputed fact numbers 1 and 2 in our statement of undisputed material fact. I believe 2 lists the 6 damages that were raised in the complaint. Dr. Eford only recognized 3 of those in his deposition, but we negated all 6 by saying, here's how Dr. Fox did not cause the damages that they're claiming. And so through damages, through challenging and using the expertise of a pathologist on the pathology slides to establish that the performance of the removal of cancer and breast tissue was appropriately done, because that was the procedure he was asked to perform, the removal of cancer and the removal of breast tissue. And there's nothing in the facts before the trial court, nothing before this court even now, even through excess briefing beyond what is in the technical record, that says that the leaving of excess fat tissue is a violation of the standard of care. In fact, Dr. Eford was very clear in this, that you have to leave a lifeboat. The biggest concern with a surgery such as this is if you remove too much tissue you're unable to close, that leads to skin necrosis, infection and disease, cosmetic deformity. And so his words and his quote, and this is in the record, was, I leave a lifeboat. It's so easy to go back and take out more. And so based upon even his own words and what he does in his practice, when you look at the pathology slides and realize that the breast tissue had been appropriately removed, that establishes there was no violation of the standard of care. Unless there's anything else, I would simply ask the court to review Judge Pemberton's well thought out and well written order, his thought and analysis from, I understand it's a de novo review, but his analysis and his order delineate in detail how the defendants established and carried their burden of negating the claims of informed consent, of health care liability under 29, 26, 121, or 115, and then negating the elements of damages. Thank you.
Thank you. Hear from the appellant, rebuttal.
Thank you, Your Honor. If you track,
Pull the microphone up, please.
if you track from the statement of undisputed facts to the brief of the appellee to the order of Judge Pemberton, they just track right along. There's no additional analysis. We don't have a motion or opposition papers. We don't have opposition facts. The facts that we have cited are in their record, not in one that we would have put in. It's in their record. In this case that I found last night and provided and let Ms. Hurt know about it, Garner v. Coffee County Bank. In that case, there was no opposition brief or statement of facts accepted by the court because it was late. And what the court did was it looked in the deposition that was presented by the movement. And there were 8 claims in that case. And the court reversed summary judgment, I believe, on 4 of them, finding that the deposition that the movement put in established tribal issues of fact on 4 of those claims. Now, we didn't put that in. It's already in theirs. And let me give you an example. I want to make sure that I say this, though. Dr. Eford said, I don't know, I can't tell how much breast tissue's in there. Neither could the surgeon at Vanderbilt. Nobody could. It was 40% of her breast. Nobody could. So they had to remove it and find out. Nobody has said that anybody could tell. It had to be removed. This lady had breast cancer, and now she's going to have 40% of her breast remain? No. She's just going to have mammograms forever.
I mean, as I understood opposing counsel, the pathologist said that there was no breast tissue in that what was removed in the second surgery. Am I wrong?
The breast is made up of mammary tissue. It's made up of connective tissue. It's made up of fat. It's made up of different kinds of tissue. There was mammary tissue in it, but that's not when a woman has a mastectomy, it's not only to remove the mammary tissue, it's to remove the breast. So if the breast is removed, then it ought to be fairly flat. This is not about, when you say leave a lifeboat, that means if you go down too far, you can cause skin necrosis. This is nowhere near that. Now, we have a picture that we put into evidence that was put in because Judge Pemberton asked for a second brief. His question in the record was, I've looked at this, Mr. Long, you're right. I didn't see anything about negligence in here anyway. I didn't see anything about negligence, about all these damages that you're talking about. So I want briefs. And a brief was put in by them that referred to this photograph that's in there. Now, if you look at that photograph, what human being would want to live like that? And the 75-25, it's not in this record about Dr. Eford, 75% of the patients. He said what he said, which was, no, I don't do this unless they've rejected the standard of care 3 times. That's what he said. And as to why she had this surgery, she said it was because she wanted to save her life, and that's the answer that was cut off and not presented. We have several examples of that where a citation is put in, but the quote for the judge was like this. When you read what's cited, completely different meaning. And so I'd ask the court to look at those because it's like cutting a message off in half. You don't know what the message was if you cut it off in half.
Your time's expired.
Thank you.
Our thanks to counsel for both sides. We appreciate your arguments today and your briefs on this. You're excused.
Thank you, Your Honor.